afternoon.
Great to be with you too. Mark, every week you come in with some interesting stories, real stories of legal cases that entrepreneurs need to know about. What's our story today?
Well, I've got a case just decided on March 7th by our Supreme Judicial Court that I think is going to cause some issues for lenders and creditors, because a little bit of a surprise decision to some folks. It had to do with what's the statute of limitations for suing on promissory notes. And the plaintiff in this case is a company called Premier Capital, which is in the business of acquiring, managing, and collecting debts. Now, Jeffrey, you're way too young to remember this, but in the early 90s, there were a lot of bank failures.
Right, I was around.
And the FDIC or the RTC ended up holding all of this bank debt, obligations owed to banks like Bank of New England and many other banks. And then there are companies that will buy the debt from FDIC or RTC. And Premier Capital is a company that's in the business of acquiring debt. So they ended up with a old note that was signed in 1987. And it was executed under seal. Remember last week we talked about a sealed, whether a contract was under seal. A painting company had a contract with the University of Massachusetts, and the statute of limitations for contracts under seal or notes under seal, 20 years, but for claims against the state is a special 3-year statute, and the court, as we discussed last week, held that the 3-year statute trumped the 20-year statute, and so the plaintiff in that case was out of luck in trying to assert its claim. Well, here we have a similar situation. So we have a note executed under seal, 20-year statute is what the general statute of limitation rule is, and then in 1998, the Uniform Commercial Code, which governs sales of commercial paper, transactions in commercial paper, and other things, was amended, and in there was a provision put in that there would be a 6-year statute of limitations from default or due date of a note. So now you have a conflict once again, 2 statutes, one that says a holder of a note's entitled to a 20-year statute, and the second is the holder of the note has to sue within 6 years. Now, some